How long can an employee be on workers' compensation in California?
So it depends. It depends on the type of injury the person has. There are certain statutes. So a usual injury, if you're only talking about temporary disability benefits, the insurance company is liable for 104 weeks or close to 2 years. 2 years. When the worker is not able to return to the job, either because the doctor is saying that they cannot or because the employer cannot accommodate. Now, there are certain injuries that extend the period of temporary disability benefits to 140 weeks. In certain catastrophic injuries, then the insurance company would be liable for this longer period of disability time. Now, sometimes the injury is so catastrophic that the person has life pension. So that would be in the end of your workers' compensation case. The medical treatment could continue if you wish. It will continue for life as long as the doctor is saying that you necessitate medical treatment for life. If those injuries are catastrophic and your disability is over 70%, then you can also get a life pension together with your permanent disability benefits.
You said if your disability is over 70%, a doctor will say this person is 100% abled or this person is 50% disabled. That's something that a doctor will evaluate. Is that common?
Yes, and that is a very complicated question and issue. So doctors who evaluate injured workers rely on a book called the American Medical Association Guides to the Permanent Impairment Rating. When the doctor evaluates you, they will consult this book to determine the amount of percentage a person has whole person impairment because of this injury. If the person is cured, there is no impairment, right? Now, if the person loses one eye, for example, it is equivalent of maybe around 30% whole person impairment. Then after the doctors give a whole person impairment, the lawyers come in and we rate the doctor's reports. To rate the doctor's percentage, the lawyers need to take into account several things. The person's occupation at the time of the injury, how old they were at the time of the injury, what body parts the doctor rated, and at the end, it will also take into account how much the person was making at the job. Then the formula will come out to like 70. If the formula comes out to 70%, whoever has 70% or more will have a life pension. Now, if you're at 70%, you have a very small life pension. If you're 100%, you have a larger life pension. But the benefits in California are not the benefits you would expect in a personal injury case, for example. The benefits are much less than personal injury cases or employment law cases.
Really? They are much less?
Yes, they are. That's what we call the workers' compensation bargain.
Okay.
So 70 years, 80 years ago, employers and injured workers, the state made a bargain, right? Every employer would need to carry workers' compensation insurance so that injured workers would have faster access to medical care, supposedly. But this means that benefits are limited. So you don't have to prove whose fault was it when you got injured in the job. You don't have to prove that it was your employer's fault that you got injured. And it really doesn't matter if it was your fault for getting injured, unless certain circumstances. Or, for example, if the person was injured on the job because they were drunk, if they started a fight, then those would not be work injuries. Those would be exceptions to work injuries. But usually you don't have to prove fault. It's a no-fault system. But the bargain here is that it's easier to find a work injury and to get medical treatment for a work injury, but much less benefits than in a civil case, for example, where you would get pain and suffering, loss of consortium. You don't get those things in workers' compensation.
Interesting. Thank you.